Consult the guidelines on your tables to prevent audio and feedback incidences, to protect the health and safety of our interpreters. I also like to remind the witnesses and members to please wait until I recognize you by name before speaking, and if you wish to speak, please raise your hand. The clerk and I will manage the speaking order as best we can. And for interpretation, please use your earpiece and select the appropriate channel for either floor, English, or French. Again, all comments should be addressed to the chair. I'd now like to welcome our witness, the Honourable Sean Fraser, Minister of Justice and Attorney General of Canada. Sir, I invite you to make your opening remarks, and you have up to 5-7 minutes, however long it will require you to make it known how great you are and how great the Government of Canada is to try to help the witnesses and our most vulnerable victims in the CAF. Go ahead.
Well, look, I'll leave those statements for others to make. Merci, Monsieur le Président. Merci tout le monde. C'est un grand plaisir.
Mr. Chair. Thank you to everyone. It's a pleasure for me to be here with you to discuss Bill C-11. Before we begin, public safety is a priority for our government. It's a major priority for Canadians at the same time.
Justice reform has been a major item on Parliament's agenda. You'll obviously have seen that as we move forward, part of that agenda involves criminal justice reform. We also want to ensure that as we move forward, we're making investments in the front line, whether that's the RCMP, our border officials, whether that's supporting frontline organizations that support victims. And we also want to make the upstream investments in affordable housing, mental health and addictions, programs for at-risk youth to help end crime and violent crime in the long term. But a major part of this strategy is going to adopt stronger criminal laws. Over the course of the past few months, you will have seen several major pieces of criminal justice legislation move forward through the parliamentary process. Of course, this includes the Combating Hate Act, which is going through the committee process, the Bail and Sentencing Reform Act, which has a sweeping set of reforms to strengthen the sentencing regime and make it harder for violent repeat offenders to be released on bail. And most recently, you would have seen Bill C-16, the Protecting Victims Act, which addresses a range of different offences and penalties touching on intimate partner violence, the exploitation of children, sexual offences, the penalties for sexual offences, including higher maximums, the restoration of mandatory minimum penalties in a constitutionally compliant way, which have been struck down by the Supreme Court of Canada, and importantly addressing delays in the criminal justice system with a particular focus on those cases that involve sexual assaults, which we know have long suffered from challenges as a result of resource shortages at different levels of government, as a result of procedural timelines that have led to, unfortunately, too many cases being rejected, not because someone's been acquitted, but for delay. We want to address these problems by implementing meaningful reforms that will deal with the delays in the system, but at the same time, do a better job of ensuring that perpetrators are brought to justice at the end of the day. In a parallel way, at the same time we've made these amendments or proposed these amendments to Canada's criminal laws in a civilian context, there are certain overlaps that have amended rules in the military justice system. Some of those changes take place not in Bill C-11, but Bill C-14 and 16, which I've mentioned, as we try to break down silos within government to ensure we're trying to solve a problem more broadly, not just in one department or another. But other reforms respond directly to the reports commissioned by leading experts in their field, including Supreme Court Justices Fish and Arbor, to make changes to the military justice system. There are two main ones that I expect will be the focus of today's conversation, though I'm happy to take questions on other matters. The first is moving outside of the military justice system's jurisdiction, complaints involving sexual offences. We have seen real challenges that were raised through the Arbor report in particular that demonstrate why it's not well positioned to have the complaint system and the tribunal exist within the chain of command. Though there are challenges in both the civilian and military system, it's been presented by Justice Arbour as a false choice with the fear of retribution, the potential interference that could happen within the chain of command that causes a culture of people not willing to come forward and to report sometimes egregious cases of sexual assault or serious sexual offenses that deserve to be investigated and prosecuted in a manner that the complainant will believe will be taken seriously. This is not to say all of the problems in one system are absent in the other, only that the path forward recommended by those who have dug into the issue and who have substantial expertise has recommended a particular path forward that was previously in Bill C-66, now making its way to this committee through Bill C-11. The second area of reforms that I expect members may wish to dig into will be about the changes structurally to have certain actors within the military justice system be appointed through the Governor Council process, again, escaping the existing challenges that exist when you have someone in these positions within the chain of command. This would more closely mirror the process that's used in the civilian system, which does allow, notwithstanding the GIC appointment, a certain level of independence in the day-to-day operations. There are other matters that I'm happy to discuss, but suffice it to say, I hope that this is a matter in which we can all work together to find the best path forward to allow victims of sexual violence or sexual assault to actually have their complaint fully investigated, to have an environment where they feel comfortable moving forward with their complaint, and ultimately, where a crime has been committed, to have justice prevail. Mr. Chair, those are my comments. Merci pour l'opportunité d'engager aujourd'hui.
Minister, I should also mention to the members in the committee that we have Mr. Matthew Taylor, Senior General Counsel and Director General, Criminal Law and Policy Section, Department of Justice, Mr. Owen Ripley, Senior Assistant Deputy Minister, Policy Sector, Department of Justice, and I see there's also Genevieve. Right. And Colonel Genevieve Lotier, is that pronounced correctly? Deputy Judge Lotier. My apologies. Colonel, I have a tendency of mispronouncing a lot of names in this committee. She's Deputy Judge Advocate General, Military Justice Modernization from the Canadian Armed Forces. Mr. Bazan, our Vice Chair, is online. You have up to 6 minutes, sir.
I believe, Chair, I'm taking the first round.
I'll pass my time over to Mr. Caputo.
Sorry, Mr. Caputo. Over to you.
Thank you. Glad you got my name right. Thank you to the witnesses for being here. Through you, Mr. Chair, I direct the following questions to the Minister. Minister, you were asked to appear and you refused, and yet you are here today. Why the change of heart?
So I'm very happy to be here. I'm glad to discuss this legislation with the legislative agenda that we've been moving forward with, including engagement with other parliamentary committees, making sure that we had the capacity to appear informed to discuss the matters. It's not a coincidence that I'm here days after we've tabled Bill C-16, the third piece of criminal justice legislation this fall. There's many priorities that we're trying to pursue simultaneously, and to make time for this committee is something that is a pleasure for me.
So to be clear, I mean, you've said it candidly, you blew off the committee until Bill C-16 was tabled.
No, I have a wildly different characterization. I would never blow off a committee, ensuring that we have the opportunity to appear where my testimony is most relevant, where we have the opportunity to manage the workflow through government, and ensuring, keeping in mind that this bill is technically the responsibility of one of my colleagues who's already testified at this committee, making sure we can advance multiple priorities at once is really part of the reason for my appearance today.
The issue is, Minister, you declined to be here, and then you accepted. And you just said that coincided with Bill C-16 coming forward. Now, I'm not sure, as a Minister of the Crown, you should be prepared to be here at any point in time. And I don't think that gives Canadians reassurance when the Minister can pick and choose when they're coming in. With that being said, Minister, I'm not sure about you, but I believe you would probably agree with this, that we should be listening to the people on the ground. They're the ones who are going to tell us whether something's working or not, whether something is good or not. We can probably agree on that, like victims, things like that.
I think it's important that we engage to understand the perspective from many people who have experience in the system, who've been tasked specifically with identifying solutions to conduct investigations,
Of course.
including people who have lived experience. And bringing those perspectives together to identify the best path forward is part of the role of governing.
And the role of government is to listen. So if we are going to listen to groups like victims and like the Association of Canadian Police Chiefs, the reality is the testimony that's been heard at this committee has been very clear. It's been unequivocal, in fact, from what I've been told, is that victims and the Canadian Association of Police Chiefs have said that victims should have the choice. They should have the choice whether to participate in an overburdened system that has repeatedly let them down or participate in the military justice system. But Bill C-11 denies them that right. Are you prepared to listen to victims, to listen to the Association of Canadian Police Chiefs and agree to that amendment?
Look, I want to understand their perspectives, but I also am cognizant of the fact that the former Supreme Court justice that we've had look into this more or less described this as a false choice because we see such a low level of reporting because of one system's existence that includes the fear of retribution, includes a history of failing victims, including potential interference within the chain of command, including the ability to share info with the military police throughout the process. A lot of people are making the choice not to come forward at all because of the personal consequences that might exist should they participate.
A lot of
in the
people are choosing not to come forward at all because of the last 10 years of failure when we have so few victims of sexual assault. And I was in the trenches for part of that time, and I can tell you how difficult it is for a victim to navigate the system. Sections 276 through 278 of the Criminal Code are very difficult as it is, and from what I understand, Minister, only one of the three justices said that there should be no choice. Victims want a choice. The police want the choice. The Provost Marshal General suggests a choice. The Director of Defense Counsel Services wants a choice. But despite all that, Minister, we all want victims to be represented. I have no doubt that you want that. So why aren't we just going to listen to victims in this case and give them the choice?
So this is an important conversation, and listening to victims has to be part of the process. But it's not lost on me that Justice Arbour, in coming up with her recommendation, worked with many victims who have experience as well, and their voice should also be listened to, and trying to figure out the best path forward, informed not only by the lived experience of some witnesses who very courageously share their perspective, but also listening to the experts who've talked to 1,000 witnesses or more, victims or more, to inform the recommendations that they've been tasked to provide is an important part of the process. And I think
let's get into that, Minister. You talked about,
the right solution.
I apologize for interrupting you. I do have limited time. Justice Arbour said that, but Justices Fish and Deschamps, both of whom sat on the Supreme Court of Canada, said that victims should have the choice. So on the one hand, you're prepared to listen to Justice Arbour's recommendation, and obviously we respect and thank the work she's done on human rights and on this, but two other justices said, no, give them the choice. And this panel has consistently had people come and say, give victims the choice. So if you're going to hang your hat on Justice Arbour's position, how can you ignore the position of Justice Fish, the position of Justice Deschamps, and the people who've appeared here at this committee? Why are you preferring one to the other, Minister?
Well, in addition to the extensive engagement that Justice Arbour undertook to land on this particular recommendation, the reasons that she attached to her report are compelling. When I understand that there is the real fear of reprisal within a person's career, when I understand that there's potential for interference within the chain of command, when I understand that very sensitive personal information can be shared outside of that particular justice process, it gives me real cause for concern that, on balance, at the end of the day, continuing through this broken system is going to do harm to more people. There is no perfect solution that will solve the epidemic of gender-based or sexual violence that exists in Canada overnight, but I believe sincerely that this is a path in the right direction to ensure that justice prevails.
Thank you, Minister.
Thank you, Mr. Kluge.
Mr. Watchorn, you have up to 6 minutes, sir.
Merci, Monsieur le Président. Puis peut-être, j'aimerais juste
I'll start by saying that we are here for victims, that we're here to find the best way to support victims of sex assault, and I believe the work on C11 has to reflect that. During our work, I referred to these specific specialized tribunals they have in Quebec to address issues of sexual assault. Some witnesses said that it seemed like a good idea. The federal government, however, needs to ensure respect for provincial areas of jurisdiction. I'm pretty sure my colleague across the way would agree. Minister, could you tell us what jurisdiction this type of tribunal or court would fall under? Also, can you tell us how we can work with provinces to encourage this type of initiative?
Qui concerne,
With respect to the criminal justice system, there are jurisdictions that we share with other provinces and territories. For instance, administrative justice is a provincial area, but the federal government can make appointments, for instance, of judges to the superior courts and other matters. But the decision to strike a special tribunal for the provinces is an opportunity for cooperation. It's an opportunity to share best practices that exist in the provinces. In my province, there are specialized courts for various issues. It's an opportunity to learn lessons from other jurisdictions, but the decision to create a special tribunal, that belongs to the provinces. I think the purpose of my comment is to say that people who address issues of sex assault have to have specialized training. What the provinces have done is that they've trained the prosecutors, the judges, the stakeholders. And how can we promote that?
just for example,
just to look at other options. If the government has the capacity, this is fictional, but if the federal government has the ability to create those types of courts without training, that specialized training, it wouldn't actually improve the lot of victims.
Ready with people who are trauma-informed, people who have appropriate training, people who have safeguards in place to ensure that people can share their stories, know that it's going to be taken seriously, that they'll be given what testimonial aids may be necessary for them to fully share their perspective. Ce n'est pas facile, et si le gouvernement fédéral insiste...
It's no easy feat. And if the federal government insisted on the provinces doing this type of thing without specialized training, it wouldn't be a good thing. But if the provinces struck up these types of courts to improve the experience of victims, then it would potentially be something that would enhance justice. Excellent. This week I had the opportunity with you to announce this bill, Bill C-16. Can you explain how the provisions in Bill C-16 will improve the victims' confidence in the civilian justice system when it comes to sex assaults?
Certainly, and C-16, and there's actually a lot of overlap between different criminal bills we put forward in a civilian context that actually amend certain features of the military justice system as well. So this may apply in both contexts. With C-16 in particular, we're focused on the creation of a new category of offenses that would lead to a constructive first-degree charge, which we're grouping together as femicide charges. There's a new offense of coercive control, and having these offenses exist will help give confidence to victims. Similarly, on a range of sexual offenses and offenses tied to the exploitation of children, the existence of those offenses will certainly give confidence. But we also will have better guidance for stronger penalties, both maximum and minimum, in circumstances involving sexual charges. But specifically, Bill 16, to your question, does two things that will very directly improve confidence in the system, not just in the law. The first is really around addressing the problem with delays, which has become, concerns have become exacerbated after the Jordan decision, which has seen almost 10,000 cases thrown out for delay. We can change that, both by shrinking the time, by improving the processes, but also having the courts look at remedies other than a stay of proceedings when there is delay. In addition, moving forward with changes to the Victims' Bill of Rights to give confidence that people know they will receive the information they're entitled to proactively, knowing that they will have access to those testimonial aids, knowing that they will have a voice victims' impact statements, and even on parole when people are being moved from one level of security facility to another, making sure that they continue to have a right that's baked into the Victims' Bill of Rights will give a higher degree of confidence in the civilian system, to your question, though there are similar changes mirrored in a military context, will give confidence that they will be able to fully participate in the process and that there is more likely to be an outcome based on the evidence adduced at trial rather than a stay issued as a result of delays.
Merci, Monsieur le Président. Est-ce qu'il reste encore du temps?
Thank you. Do I have any time left, Mr. Chair?
Okay,
No, thank you.
merci. Monsieur Maxime Blanchette, Jean-Claude, you have up to 6 minutes, sir.
Merci, Monsieur le Président, Monsieur le Ministre.
Thank you, Mr. Chair. Welcome, Minister. All serious experts, Arbour, Fish, Drapeau, Deschamps, affirm that it's important to have a separate organization outside of the chain of command to protect victims from reprisals. Why is your government saying no to this essential option when 80% of survivors never actually report crimes and the confidence has been lost?
Pour comprendre la question, c'est OK si.
Sorry,
We're rejecting that there should be a process outside of the chain of command?
Monsieur le Président, je ne sais pas si c'est un problème de traduction.
Mr. Chair, I'm not sure if it's a translation problem. I wouldn't want to waste my time. The minister doesn't seem to understand the question with the interpretation.
La question, just...
Oui, merci beaucoup.
Yes, thank you. So look, all the experts, Arbour, Fish, Drapeau, Deschamps, have affirmed that there needs to be an independent organization outside of the chain of command to investigate, receive complaints, and protect victims against reprisals. What I'm asking you is why is your government refusing this essential mechanism whereas you know 80% of survivors never report the crimes and that there's a lack of confidence that it's broken? I disagree. Actually, this is why we're looking to change the system, to avoid the problems that we're having within the military context, changing the rules to ensure that the person has the capacity to
system exists outside of the chain of command and provides the opportunities that you've very rightly pointed to.
Vos propres principes nationaux de 2023.
Your principles 2023 on the jurisdiction considers the interests of victims, but why is C11 imposing a mandatory transfer, whereas victims have clearly indicated their preference for the military system or a refusal of a criminal investigation?
I may be repeating myself from a previous answer. My position on this reflects Justice Arbour's issues that she raised, which really creates a false choice, where inside the military system there are those fears of reprisal. There are potentially very serious personal consequences that a person may face. There's a culture where people lack confidence in the system, which is causing them not to come forward to report. The choice that's being presented to continue through a military system is not one that I'm comfortable with, given its history of failing victims and given the low level of reporting of offences overall. My honestly held belief, reviewing not only the recommendations but the reasons given, are that it will be a better outcome for victims if we move into a civilian system.
Alors, Monsieur le Ministre, vos propres données montrent
Minister, your own data shows that 58 cases have been refused by civilian courts or resources because of a lack of resources, even before this miracle bill that you just tabled. What are you basing this on, that the civilian system can absorb all these cases with no delays, and given Jordan?
Context, the incremental add to the civilian system, which will be in the range of 100 cases potentially a year, compared to the tens of thousands that exist, will not fundamentally change the ability of the civilian system to handle it. There are existing problems with the civilian system, and we are working to address those. And I don't want to be understood to say one system is perfect, the other is not. The bill that we're putting forward is going to change what courts should be looking at in terms of the remedy if those delays are exceeded, but will also attack the underlying problem of delays. It will require continued work with provincial governments to ensure they make the investments to move through cases expeditiously.
Monsieur le Ministre, le projet de loi...
Minister, Bill C-11 transfers to police forces, prosecution, and civilian courts a very heavy burden. It's expensive. Why would the provinces in Quebec have to absorb all the costs of this federal reform?
So when I have conversations with my counterparts in every part of the country, everyone wants to see these cases prosecuted. I have not had any provincial counterpart come to me and say it's going to be too expensive to prosecute sexual assault cases. I sincerely believe, without exception, every one of my counterparts, regardless of province, regardless of party, actually wants to see these challenges addressed. No one is happy with the delays, and there seems to be a willingness to work together to identify how we can move forward to avoid these kinds of
Donc,
challenges.
vous confirmez que l'argent va suivre.
So you're
avec-
confirming the funding will flow as well with these responsibilities.
Made no funding commitments. We work with provincial governments consistently to understand what their needs are. There are elements we have responsibilities for, including the expeditious appointment of judges in superior courts. There's administrative issues that provinces have conduct of, including running the provincial court trials.
Monsieur le ministre, depuis Deschamps en 2015, aucun haut
Minister,
gradé
since Deschamps 2015, no senior military member has taken, nor political figure has taken responsibility for these acts. How can you ask survivors to trust the reforms made by the same government that allowed this culture to prosper for a decade?
So I think that what's important is that people actually look at the plans that are being put forward, look at the text of the laws that are being put forward. We're not asking people just to blindly trust anyone. People who've been through traumatic sexual assaults obviously are right to question the sincerity of the actors in the justice system and in the political system. But what we're asking people to do is to actually review the changes that we are proposing, to identify whether they're going to have a meaningful impact on the process that victims experience as they go through such a challenging and traumatic experience of often reliving the underlying criminal infraction that led to them being before the court, and particularly in a sexual assault context.
Thank you. Ms. Gallant, you have up to 6 minutes.
For you, Mr. Chairman, to the minister. So I never thought I'd hear the day the Liberals said they would deny a woman's right to choose. And they want choice in this matter. The concern is that the less egregious assaults will be they'll get away with it, and it just escalates over time. So have provisions been made so that the lesser assaults will be addressed fully within the military system, since they won't be addressed in the court system?
Just before, I don't think it's necessarily appropriate to be trying to meld together conversations about women's reproductive rights and the different court systems. And more broadly, I just find I find this point very important that I made it several times. I don't think it's a real choice that exists today. Justice Arbour's position on this explained that the so-called choice being presented to victims is one, if they go through the military justice system, is one that has a culture where there is very serious fears of reprisals, personal consequences that could come to the victim in their life and career outside of the criminal justice process, the potential for sensitive information to be shared about their assaults.
We've heard that from the witnesses themselves. So with that, recently we saw in the news that former General Denis Fortin was acquitted of what he was accused of. Had that taken place completely, if it had taken place in these actual civilian courts, he would not have the right to defense counsel, whereas the way it's handled now, they do. The people who are the accused are covered by military defense attorneys. So is there money going to be allocated to ensure that the people have the same rights and protection in having their court case defended as they do now through having the military defense counsel?
Look, I obviously can't comment on individual cases, but it would go through the civilian context. This is not a scenario where different governments cover the legal costs of defendants who find themselves before the court.
Actually, it is. But have you actually spoken or consulted with the Minister of National Defense prior to your introducing C11 in the House?
We had spoken on a number of occasions and actually on an ongoing basis, because it's not just C11 that has concern for a common problem that we're
About
trying.
C11, because you know, we all talk with each other, but did you specifically speak about C11?
In combination with other bills, yes.
Okay, so why hasn't the Minister of National Defense asked for your input on this particular bill?
We're members of the same cabinet. We have input on each other's decisions in all instances.
Okay. Have you assessed the impact of moving the misconduct cases from the military justice system to the civilian court system, including the cost and the greater possibility that the cases are going to be thrown out because they just run out of time due to the Jordan decision?
So we have considered, and when you look at the comparative volume of in the range of 100 cases annually in the military context compared to tens of thousands of complaints that are made publicly in the civilian context, the incremental difference for the system is not great, although the impact on the individuals is obviously of a significant magnitude. On the issue of the impact on delays, that is a problem that we want to solve, and the reforms that have been included in Bill C-16, we have confidence will have a meaningful impact to both reduce the delays that people experience and change the outcome as a result of the Jordan decision.
So when you take away the choice of where the case is going to be tried, what happens is it is often a career decision when a woman decides whether or not she is going to take the case and have it go forward. So if they don't have that choice, it condemns a number of women to being kicked out of the forces because they actually spoke. Has that been taken into consideration? And if so, have you spoken to victims about this?
So that is a real phenomenon that is motivating part of the decision to move away from the military justice system for these kinds of cases. And it's our view that when you present people with a system where superior officers potentially have the opportunity to engage in the justice system, where you have information that can be shared that's very sensitive, that can be shared throughout the chain of command, it creates a culture where the exact phenomenon you're concerned about impacts people's life and career, and we think there's a better
Point of
path.
order. Mr. Speaker, Mr. Chair, for the sake of the interpretation, I'd ask that the member allow the minister to answer so I can actually hear the translation. Thank you.
Please proceed, Minister.
Oh, so, that was my answer.
With that, when they have the chain of evidence, we've heard several situations where the chain of evidence was the evidence was thrown out because they didn't trust the chain and that it was secure that all the way through. So, what in C11 ensures that any investigation, initial contact with a victim, will be preserved in such a way that it won't be thrown out of court?
Well, you would be dealing with the protections that exist within the criminal justice system more broadly. You have the opportunity to have an independent investigation. You have the opportunity to have the independent crowns who are going to be laying charges, be moving through the criminal justice process. And that system, in my view, being separated from the military justice system, being separated from the military chain of command, has a greater degree of independence than currently exists within the military system today.
Still the transfer, and it's in the transfer of one system to the next where the evidence may be thrown out. So are there provisions in the bill to take care of that?
Yeah, but this who actually is going to be running the investigations will matter here. And when you have the ability to have the investigation to exist in an independent context, I have a greater degree of faith that the path forward will be an improvement in a civilian context than
Even if it happens in theater.
Well, there's a difference between what may happen inside of Canada and outside of Canada, and that is an area that may be helpful ground for this committee to study further.
Yeah.
Thank you. Mrs. Vivian Lapointe, you have up to 5 minutes.
Thank you, Chair. My Conservative colleagues seem to indicate that this is an either-or situation where you pit one witness testimony against another, and nothing can be further from the case. All witness testimony is important, and all of them go forward in developing the recommendations and the legislative changes that are before us today. Minister, earlier you mentioned opportunities with the provinces to improve the civilian justice system. And Bill C-16 introduces further measures to strengthen independence, oversight, accountability, and also within the military justice system. Can you tell us how C-16 complements the reforms in C-11 and responds to some of the concerns raised about consistency, transparency, and trust in the complaint and investigative process?
Certainly. And so I mentioned at the outset that when we sit down to try to identify the right legislative path forward as a government, we're trying very hard to work across departments to break down silos, and we're trying to focus the conversation on what problem we are trying to solve rather than who's got a responsibility for what policy. In this instance, we're trying to solve a very real problem with victims in both a civilian and military context who don't feel comfortable coming forward reporting sexual assaults or sexual offenses more broadly, with victims who, when they enter the system, often at the end of the day don't receive justice. In a military context, that obviously can have a very serious impact on a person's life and career. In a civilian context, there are other challenges that we're addressing through delays, for example. Some of the ways that we're trying to bring these together is having the common adoption of new offenses that happens, it's incorporated by reference in a military context, but also by addressing things like delays through similar means, adjusting the Victims' Bill of Rights and the equivalent entitlement to certain processes in a military context. We want to ensure, regardless of which system a person finds himself in, and regardless of the context in which an assault takes place, that people have access to a system that will be run independently, that they trust, that will allow them to see justice at the end of the day. We have work to do in both a military and civilian context, but we are doing that work now, and Bill C-16 offers significant reforms that will improve, in my view, both systems.
As Parliament currently considers both C-11 and C-16, what should Canadian Armed Force members and survivors understand about the government's broader plan to modernize the military justice system and ensure that independent, accountable, and trauma-informed processes are in place?
That we, A, want to address the problem, but B, want to build a system that people can trust. There is not a lot of trust for survivors of sexual assault in Canada, in either a civilian or a military system. And it's no wonder why. People will try to report crimes, and they're not believed. They're dealing with sometimes frontline officers who may have good intentions but don't have appropriate training. They'll be dealing with crowns who may not be trauma-informed and can sometimes be viewed as coldly assessing the likelihood of conviction in a circumstance where a person's being re-traumatized, telling their story yet again to another actor within the system. Should they find themselves before a court or tribunal, they're being asked to tell their story again, being cross-examined, questioned, having doubt cast upon the most traumatic experience in their lives. What we want people to know is the changes that we're making are informed by people who do have lived experience. They're informed by people who have spent their careers working in the field, and we have, based on those engagements, good reason to believe that we can and will improve the system. It's going to take some time for some of these changes to take hold. Some will have a positive impact more quickly. Others will be fully implemented, not over the course of the next few days, but will take time for the systems, potentially a few years, for people to be fully trained, again, depending on which provinces are making which investments, the supports that they tap into from the federal government, and the processes being fully baked in not only to the system on paper, but to the culture and practice. But this is a problem that we are committed to solving, and the bills that we've put forward, whether C-11, C-16, C-14, we think will have a meaningful impact, and we hope people see that we're working hard.
I just wish to let the minister know that when C-16 comes up for debate and when it comes before us, we'll invite you to this committee to talk about the bills that we haven't debated in the House yet as well. Thank you.
Thank you, Ms. It's not a point, but proceed, Mr. Minister.
Certainly, and look, I'll wait for the direction of the House to determine which committee will be studying which bill, and I expect fully I will appear at one committee or another on all of the bills that I have responsibility for, and in this instance, some bills that my colleagues have responsibility for. I'm happy to show up at these things, and I honestly believe Parliament has a role to improve the quality of legislation that's gone forward. I know Mr. Caputo is no longer here, but my experience working on his private member's bill showed that collaboration can help strengthen legislation to hopefully get to a point where multiple parties can be supporting changes that are in the best interest of victims of crime.
Chair, I'd like to go back to my time of asking questions of the minister. Some witnesses highlighted gaps around information sharing, timelines, and oversight. Can you tell us how Bill 16 helps address these issues, and how will its measures work alongside C11 to create a clearer and a more survivor-centered system?
Point of order, Mr. Chair. We are talking about C11, not Bill C16, so I would expect that questions are directed about Bill C11.
I did reference C11 in my question, but thank you, Colin.
No, you said C16.
I said work alongside C11 to create clearer, more survivor-centered system. Perhaps you didn't hear that part of my question.
Thank you, Ms. Lapointe. It's your time. Proceed.
So the question's to me, Mr. Chair? Okay, thank you. So there's a number of different ways that C16 and C11 are tackling similar issues. And typically when I appear, I'm able to take questions on my portfolio more broadly. But C16 actually does have measures that are of direct concern to this committee. Look, for example, at the work that we're doing to combat delays when it comes to records in sexual offending, for example. In a civilian context, we're streamlining and strengthening procedural rules in sexual assault trials, the adducing of evidence, for example, the production of private records of persons' individual medical or psychological records, exchanges between the complainant and the victim that can be adduced to streamline the process to make it go forward. We've got very similar reforms that are included in a military context in Bill C-16, and we believe that when we actually have those align well with one another, we're going to be able to ensure that there's some consistency as between processes, but importantly, at the end of the day, regardless of which system we're dealing with, people understand that the process will be timely, that it will be fair, and that it will be reducing the trauma that people are required to re-experience as they share their story once again.
Thank you so much, Angel, for the huge super chat. Holy smokes.
Monsieur Maxime Blanchard, okay, back to you. You have 2.5 minutes.
Monsieur le ministre, vous venez de parler de
Minister, you refer to consistency in procedures for, and I'd like to refer back to the national statement from 2023. The statement said, on concurrent jurisdiction, there were factors such as the victim's preference and other things before you select the jurisdiction. Why is it that under C11 there is no more flexibility provided by your own prosecutors? Can you explain that?
J'ai donné les mêmes réponses.
I'll provide the same answer as to another question.
Real choice. And this is not just my opinion. This is a reflection of the arguments that Justice Abor laid out in coming upon the recommendation to move into a civilian context. It is about the fear of reprisals. It is about the culture of distrust that exists. It is about the potential interference when you're dealing with actors who exist within a chain of command. These are very real concerns that cause me to believe that it's not a real choice that's being put to victims today.
Monsieur le ministre, est-ce que vous
Minister, do you recognize that you're casting aside your own principles? This is 2023, 2 years ago in the national statement. Do you recognize that?
Yeah, I think, are we talking about the interim directive? This was put in place to get legislation through a minority parliament, and we're working hard to implement the permanent fixes now.
Ouais. Monsieur le ministre, je comprends, vous regardez votre téléphone.
Minister, I understand you're looking at your phone. You don't have the answer. People are trying to give you an answer. Unfortunately, that's embarrassing. A government wants to restore trust in a fundamental principle like this one. The issue of victims. No, you're saying, well, it was a minority government. Seriously, how can you roll back a principle that you yourselves passed through your own prosecutors even just 2 years ago? Explain that to me. How can people have confidence in your government?
I think there's a real answer that's important here. We wanted to be able to move quickly to offer some relief in the short term while we move forward to implement permanent fixes. The permanent solutions are included in Bill C-11. I think there was value in moving forward expeditiously on an interim basis so we can provide some relief immediately as we work to establish a permanent change to the regime under which these cases are
Monsieur le
heard.
ministre, moi, ça me confirme.
Minister, this confirms that, again, you're reacting to crisis. There's no planning. Once again, you're dealing with a crisis after the fact. It's been 10 years you've been in government, and the situation's only worsened. And now here you are, and you're unable to tell us this, explain this contradiction that I see with your own prosecutors. I'd like people to trust in the system, but you're not demonstrating any reason for that.
I have a fundamentally different point of view. We know that there has been a long-standing challenge when it comes to sexual offenses in the military for generations. We particularly, upon what was Minister Anand's appointment at the time, there was quick action taken to ensure that we had the right information to ground permanent changes, including the generation of reports that were put forward by those who did deep study, who are experts in the field, using their recommendations to ground both a short-term fix in the interim and now the long-term solutions that are going to be found in Bill C-11, I believe, is the right path.
What you just...
Sorry, Mr. Kibble, you have up to 5 minutes.
Thank you, Mr. Chair. It's disappointing we're focusing so much on Bill C-16 and showcasing that before it's being debated and not C-11 and the particular instances of military sexual trauma. We've heard heartbreaking testimony from many victims, Minister, and survivors. Overwhelmingly, they have said they want choice. We've had the testimony of Justices Deschamps and Fish who say they support choice between the two military and civilian justice systems, and you only focus on Justice Arbour's report. I think that everybody's voices should be included. I think that all of those recommendations should be included and not just cherry picking. Victims have said overwhelmingly they will not bring many of their cases forward to civilian courts, including the low-level ones. In fact, many of them have reported that their cases have been turned away from the civilian system. Why will you not hear their voices of everyone, hear the majority of voices, and why do you insist on taking away choice so that victims can choose, and this is military sexual trauma, which is very different than just sexual trauma, why do you insist on taking away that choice from them between those two systems?
So, very respectfully, I have a sincerely held different view. The choice that I see playing out right now in the military context is for so many people not to come forward at all. It's for the reasons that I've outlined. Mr. Chair, do I have time to offer a response similar to the length of the question?
This isn't about your view. This is about the view of victims of military sexual trauma, and we've had
Mr. Chair, do I have an opportunity to offer responses?
My apologies, Chair, but interpreters cannot do the work that they need to do when we have two people talking over each other.
Mr. Kibble, I'll give you a few extra minutes, but I'll let the Minister respond, please.
Thank you, Mr. Chair.
On this issue, my view is informed by the reports that have engaged 1,000 victims or more. My conclusion is that there are many, many people who are choosing not to come forward for the reasons that I've articulated previously in this session. That includes the fear of reprisals. It includes a lack of independence when you have actors in the justice system who are subject to the chain of command. There are very real consequences to a person's life and a career that's causing them not to come forward. When we see 100 cases nationally in that ballpark coming forward, I expect that there's a significant number that go unreported compared to the tens of thousands that we see reported across the country in a civilian context. I'm not arguing one system is perfect. I think there is a better path than exists today.
Thank you, and I appreciate that, but this shouldn't be about your view of this. This should be about the view of the victims, and I appreciate you've heard from thousands of victims, and overwhelmingly they have supported choice. I've also, earlier in your testimony, I was glad to hear that you said that civilian police have appropriate training in dealing with sexual assault. I think that's very important, and that they're trauma-informed, and you acknowledge that. However, military sexual trauma is very different. Police, including the Victoria Police Chief, have said that police services, and they deal with multiple, the potential to deal with the cases at CFB Esquimalt, second largest base in Canada. Victoria Police Chief has said that they would need specialized training in dealing with military sexual trauma, that they would need funding to support the extra work that they do not have the capability to deal with. These are hundreds of cases potentially that are coming. Will the government give them support, ensure that they have the training dealing with military sexual trauma and its differences, dealing with different evidence handling, records, personal records, and access to information? Thank you.
Thank you. So we do have programs that support this kind of training through the Victims Fund. Whether there will be an application forthcoming, I'm not aware of that. But that is an opportunity for us to actually work to ensure that there is appropriate level of training for people who understand the unique context. And I accept the context would be different in a military context.
So thank you that
well.
there's a training available. But I'm speaking specifically of funding in the millions of dollars that civilian police forces and provincial justice systems are going to need to take on this extra load and this extra training. Will the government provide those millions of dollars? We've even considered or asked anybody about that extra load and training and dollars that will be needed to support this just being thrown onto the civilian justice system.
Well, the creation of the Victims Fund was partially motivated by the need to address these very specific kinds of things, because we're seeing specialized courts pop up in different parts of the country to address these kinds of concerns. We don't obviously have a funding announcement to make at this parliamentary committee hearing, because we would require an application to come in, to be assessed, to actually work with the proponent who would be seeking to tap into these federal funding opportunities. So there are funding opportunities there, to answer your question directly. Whether we have a specific one in Victoria for the local police force or court systems would depend on engagements that would need to take place in advance of funding applications.
Anderson, thank you. I know that you added.
Yeah, it's expired. Okay,
So
well,
you said
go,
you-
Mr. Anderson, go ahead. Go ahead.
Thank
Want
you.
to ask one question?
Well, I don't have one question. I've got a bunch of
We'll have to wait for your time at that, if that's the case. Mr. Mallette, you now have 5 minutes.
Thank you, Chair. And we've been listening this morning to our friends across the way who are suggesting that there is an apparent overwhelming majority, I guess, as we're hearing of witnesses and victims who have testified here, that they could not get adequate redress in either system or in the military. They want the choice to go. But I would suggest we've heard just as much testimony or as in-depth testimony of victims who were assaulted, Mr. Minister, who feared the system in which they were assaulted is now the system in which they're seeking redress for that assault, but they're doing so before the very people or the very institution in which they were assaulted. And this has been consistently some of the observations I've made in our deliberations here on this matter. Specifically that, and I've drawn this parallel before, that women, in the cases of the sexual assault courts-martial that I myself have witnessed, they were all women involved. They were women in uniform, filing a complaint with someone in the same uniform, appearing before a tribunal of everyone wearing the same uniform. My question then is, where is the trust if we limit it, if we don't remove it from that system, is I guess the fundamental choice or question here.
Look, first, you sort of in your preamble described questions coming from our friends, and I think that's important to remind. I think we are friends who want the same outcomes, and what we have to figure out is the right path to obtain those outcomes. You make a very important point. It's hard for a person to have trust in the system where their assault took place if they know that there is a chain of command that exists in which that complaint will take place. And within that chain of command, there are individuals who would potentially have the authority to severely limit the personal consequences outside of the criminal implications of the assault that they may have lived through. You can imagine putting yourself in the shoes of someone in that system who says, if I open my mouth, I could be fired, I could be denied a promotion, I'm going to be chastised by my peers. Putting this entire process in the hands of the independent civilian process, which will not be subject to the chain of command, is not only going to lead to potentially better outcomes for the people who do come forward, but potentially to more people coming forward because they'll have greater trust in the independence of the system. I think that is precisely the right point.
Yes, and further to that, I think we have heard testimony from at least one witness who testified exactly to that point, and in fact, it was the complainant, the victim's immediate superior officer, who was alleged and to have perpetrated the offense. If I can move along to, we heard witnesses talk about the importance of having specialized resources for sexual violence crimes, but also that judges need the necessary training to handle these types of cases. Minister, what training is currently available in the civil system, and are we looking at methods of enhancing that training?
Certainly. And look, before we get into the specific resources that are available, knowing that there is a system that has the expertise to handle these kinds of cases is key to developing that trust that I referred to in my response to your last question. My first few years as a member of Parliament, I sat on the Status of Women Committee, and we conducted a lengthy study about the experience of women who've been subjected to gender-based violence. And the lack of expertise in policing amongst Crown prosecutors within the courts is a major problem within the justice system more broadly. The level of training that exists and the level of specialization. Sorry, Mr. Chair?
Mr. Anderson, we can hear you. Just keep it down. Thank you.
May I continue? Thank you. The level of training and expertise that exists can be inconsistent as between different provinces in Canada within the civilian system, which is something that we should seek to address and borrow best practices from one another. But you are seeing some unique practices emerged. One of our colleagues referenced the specialized tribunals that exist in Quebec. There are other provinces that are launching specialized courts to deal with these kinds of cases. We have made resources available for these kinds of training, but we're not trying to predetermine for provinces where they should be spending resources. We're trying to put funds on the table to say, when you develop with full knowledge of the culture that exists within your region, with the ability to actually deliver results with those training, we're making resources available to help address the priorities that emerge at a local level that will best meet the challenges that exist at a local level.
Yeah, and further, well, sorry.
Mr. Mallett, that's
time.
time.
Okay,
Mr. Anderson, back to you now.
Oh, good. Thank you, Minister. Do you have any military experience?
No, I have not served in the military.
Okay. Do you understand the difference between chain of command and the military prosecution system?
I know that those are distinct concepts, but in this instance, there could be interplay.
Well, not really. You've used the term within the chain of command, interference within the chain of command. How do you understand the chain of command, the relationship?
In general terms?
In general terms.
That you would have a reporting officer that you would take orders from, and they may have a officer superior to them, and so on.
And what is the relationship to the military justice system?
Well, there is potential for information sharing.
No, not
that
potential. What is the relationship between the two?
So my concern is not just...
I'm asking you what the relationship, what your understanding of the relationship is between the chain of command and the military justice system.
Though there are distinctions, my concern is that there is information that can bleed between one and the next, and that the folks who act within the chain of command could have reprisals come to the individual who makes a complaint within the military justice system.
Okay. Well, that's extremely tenuous given the relationship between the two of them. Are you aware that each case transferred to the civilian system has hundreds of hours of investigatory hours attached to it?
It would depend on the specifics of the individual case, but it would be possible, certainly, depending on how far advanced the investigation is.
We're transferring 100 cases there. It's as if it's nothing compared to the tens of thousands. It actually is. It's if you do the math, it's...
I don't want to be understood to say that it's nothing. Every one of those cases is a big deal and is very meaningful, particularly to the individuals involved. The comparative volume is a factor that we should consider.
And you have heard the Chief of Police of Victoria saying that they simply can't handle this without any resources.
And I think that we would need to understand how to make sure that the civilian system is equipped to handle these, but some of the changes that we're making will improve
by
that.
transferring money to them?
Potentially through the training programs that I've discussed at this committee earlier,
okay,
but also by changing the processes to speed up the process of getting through trial and to avoid the consequences of stays for delay.
Okay, I want to return to choice here. The idea that removing choice is a benefit to the victim, that to me seems to be one of the most paternalistic almost mansplaining that we shouldn't have a choice, in spite of the fact that every victim, that except for one that has turned up here, has said that they prefer a choice, that they would feel much more secure having a choice, that there are many incidences in which they may want to remain within the system. Furthermore, we heard testimony from the military justice system itself, both the prosecution and the defense and the Provost Marshal, that they have the capacity, that the culture has changed over the past 5 years or 10 years, that they are significantly more ready to prosecute these things in the military, if necessary, if the victim chooses to do that. I cannot think of a good, we seem to be going around in circles. You're giving us all sorts of reasons why you feel that this, in spite of the evidence and in spite of the testimony, are you prepared to maybe make a choice if you re-examine the evidence that victims should have a choice? Is that open in your mind at all, or is this a closed book?
So the evidence that we've reviewed includes the report that was commissioned for the specific purpose of
Several
addressing
reports,
this challenge.
many of which have thousands of victims. That's not the question. Are you prepared to contemplate putting choice back into this bill?
My point of view, informed by the reports that were commissioned to address this issue, is that the system will be improved on the whole if we move these sexual offences into a civilian context.
You intend to remove choice?
There is a false choice that exists. You continue to say
No, sir, there is not a false choice.
The choice so many people are making right now is not to come forward because they do not believe it will result in justice. They believe that they will be re-traumatized.
Tell me what happens then, because nobody else can seem to answer this. On a low level thing, we've removed jurisdiction from the military for sexual assault. Is that correct? In C11? It says that we have.
Yeah, I understand what you're saying. There's some unique context around the interim directive and the process that continues to exist today, but...
That's correct. Yeah. And so a low-level thing, a pat on the bum, is not going to be prosecuted. Yeah, we've got that definitely from one of the justices that appeared here. 2 pats on the bum probably won't be prosecuted as a criminal offense. What does the victim do? How are you planning to change the culture in the military if all of the low-level stuff is simply ignored because the military doesn't have jurisdiction to deal with it?
Well, I still think that it's important that you maintain a complaints process.
To who?
Well, it will depend on the context. Sometimes if there's a serious sexual assault, it could be a full-blown prosecution.
Sorry, we're going to be wrapping up soon. Sherry Raminato, last point, and then we'll suspend.
Thank you, Mr. Chair, and through you, I'd like to thank the Minister for coming today. Minister, you know I have 2 sons and a daughter-in-law serving in the Canadian Armed Forces. We also know that in 1998, we moved from the civilian system to the Canadian Armed Forces, the investigation and prosecutions of sexual assault. We also know that from 1998 until 2021, when we had significant reckoning in the Canadian Armed Forces, that many members of the Canadian Armed Forces who were victims of sexual assault never came forward, as you said, in terms of a false choice. Their choice was to stay quiet or risk losing their job, being ridiculed. They've chose to serve this country, and they did not come forward because they knew they had no choice. And we heard that in testimony. In 2021, we had the interim directive to move these investigations and the prosecutions to civilian courts. We've implemented a significant culture change. At that time, the CDS also engaged with over 14,000 members of the Canadian Armed Forces and former members to get their input in terms of how we should move forward in changing that culture. The goal is not about making sure that investigations and prosecutions happen. It is to ensure that this behavior stops. We are asking men and women to put their lives on the line. We're asking families that support members of the Canadian Armed Forces to trust the system. There was no trust in the system in 2021. We are rebuilding that. My question to you, other than the RCMP, is there any other workplace that would investigate and prosecute their own? I don't believe there is. And that is why we are moving with C11 to give victims, both male and female, justice. And it's also improving the culture in the Canadian Armed Forces.
Is there a
Would
question
you agree
here?
that with the implementation of C11 and that recommendation strictly from Arbor's report to make sure that the prosecution and investigations are taken out of the hands of the Canadian Armed Forces, moved to the civilian system, will help bring back the importance of believing in the system, trust in the system, and faith in the system?
In a word, yes. If you'll allow me what time I have remaining, Chair, you're right to focus on solving the problem and not just choosing one system or another. And trust is an essential ingredient to solving this problem. Switching to one system overnight is not going to solve the problem in and of itself, but it is an essential first step if we're going to rebuild that trust, which will take time. Now, we're also going to need to address very serious systemic challenges that exist within the civilian system, no question. But from where I sit, having seen the report, having seen the engagement with 14,000 members of the CAF, having seen 1,000 victims participate in Justice Arbor's considerations, it's pretty clear that the existing system's not working. Whether it could even be rebuilt with all the resources in the world, given the fundamental lack of trust, is a very real question. And I've concluded that it's not possible for people to see trust when they believe that there will be reprisals for speaking out. In addition to the impact on the individual victim who doesn't see justice, at a time when we're trying to recruit actively people to join the Canadian Armed Forces, telling women that their experience will be something different than what it has historically been would not be honest. People will leave the service. People will not join service. And if they go through a traumatic experience such as sexual assault, the incentive is to stay quiet. Otherwise, you may be punished. This is not justice. This is a system that will simply not serve the interests of the country, the forces, or the individual. So, in my view, it's an essential path forward to move this into a civilian context. But we need to do lots of additional work after we make that essential change.
Thank you, Minister. Thank you all for your participation, to the other witnesses as well. I will suspend for a few moments while we now move over to the Coast Guard witnesses. Thank you.
Seconds. Cut me off.
All right. So like I said, that we were only going to cover this for the first hour because that's when the minister's in, and then we've got a bit of a break until the next committee. So at 11 a.m. Eastern Standard Time is the Public Accounts Committee, where we've got the Office of the Auditor General in. We've got Erin O'Gorman, the head of the CBSA, in, which I don't even know how she still has a job, but we're talking about some of the Auditor General reports, and we'll cover that before up until question period. Well, an hour before question period. Then we've got question period. Then we've got go after, and that'll be it for today. So I think I've put the link in the chat before, but there it is again. And before we take a bit of a break, thank you so much, Raven, for the 10 gifted. I really appreciate you. And Angel, I did say it before, but like, wow, really, really crazy large super chat. That's like the second biggest super chat I've ever had. So thank you so much for your generosity and both of you guys for your support. Ladies, but you know what I mean. Sorry, just checking the chat here. Okay, yeah, that's it. We'll leave it there, and I'll see you guys shortly for the next committee. And thanks for tuning in and watching, and see you guys soon. Cheers, guys.